So today we're going to be talking about the polluter pay principle. And what do we mean when we're talking about the polluter pay principle? The administrator of the Ship Source Oil Pollution Fund, as you may know, has a twofold mandate that's built into the legislation. Her mandate is first to compensate victims of oil pollution damage. Primarily that is through the assessment and paying of claims, the more traditional component that we know as a means of access to justice. The second component is upholding the polluter pay principle. And that is also a function of access to justice because there are a lot of impediments to upholding that principle, be they financial, ownership-related, etc. And, I'd like to spend a little bit of time on polluter pay and the recovery element today. But before we jump into that, what do we mean polluter pay principle? Polluter pay principle is, it's not per se a statutory phrase. It's a policy of the federal government across all of the departments to say, okay, these are the people who have to pay first. But where do we really see that in the legislation? Where do we see that? Well, the first thing that we see is strict liability throughout the regime. So whether it's international conventions that apply in Canada by way of the Marine Liability Act, or if it's the Marine Liability Act itself with the general regime, polluter pay is found there. There is strict liability. And what does strict liability mean? It means that there's no need to prove fault, civil fault, or negligence, or neglect, or any other kind of traditional tort liability, which is not always easy to do, especially not for a lay claimant or a lay litigant. There are various definitions of ship owner. That's another indication of the polluter pays principle. When we're talking about a tanker, the owner is the registered owner of the vessel, and that has a very restrictive definition that the international community decided that's who we wanted to be liable. And then, but under the Bunkers Convention, if that convention applies to the incident, well, that definition is broadened. That definition includes other people like a bareboat charterer, commercial managers, and operators of the vessel. So there's more people in the pot of people to go after if somebody's actually caused harm. And under Part 6, Division 2, under the Marine Liability Act itself, if none of those conventions apply, it's basically anybody who has, any possession and use rights to the vessel at whatever the time is. And that's a very generous definition, but as we'll see a little bit later, sometimes the courts are taking a little bit of a restrictive definition of the person who at the time has those rights. And that's problematic because Part 6, Division 2, the Marine Liability Act in general, is meant to be a catch-all. It's meant to be a statute that applies where no other statute or no other convention will apply. So it has to be just as generous, in my opinion, if not more so, than the international convention. Another example of polluter pay, and the polluter pay principle, is the liability of the administrator. Under Section 101 of the Marine Liability Act, the administrator is only ever liable to pay for something where a ship owner has demonstrated an inability to pay, or that they've exceeded their limit of liability, or that no ship owner exists, or it's a mystery spill and stuff like that. So this is, very clearly, before the administrator goes ahead and says, oh yeah, sure, I'm going to pay, there has to be some demonstration by a claimant or a litigant that the ship owner's been turned to and either asked or, you can just tell this ship owner is not going to respond, etc. And that's when the administrator can basically check in and pay for something. She's given broad powers under the Marine Liability Act, not only to investigate and assess claims, including subpoena power, but she's given an extremely strong power, the power to arrest a vessel, bring an action in rem, or an action against a vessel, before she even not only pays a claim, before she even receives a claim. So if an incident happens, the administrator just, okay, this is something that may trigger the Tankers Convention and the regime. It may trigger, the Marine Liability Act only. It doesn't matter. Somebody's likely going to be on the hook for something. She has the power to then arrest that ship and have somebody put up security. And it's a power that is, rather exceptional. That's an example of the administrator's role to play in polluter pay. You can see in the statute that the administrator has not only a right, but an obligation to recover when she's paid out a sum, that says you have to get in there and do everything that is reasonable to get somebody, the ship owner and ship owners, depending on the definition, to actually pay for this. What is reasonable depends on the circumstances, including the capacity to pay at the end of the day. And lastly, that obligation to recover is against not just the one ship owner, but not only the ship owner, depending on the definition of the ship owner, but against including all other persons liable. That can be, a third party who's, a tortfeasor, it could be a bailee, it could be anybody who fits a more extended definition of somebody who had enough interest in this vessel to attract liability. And we'll see in the case of the Crown Forest later that it's not always easy to distinguish who has skin in the game. We've obviously heard about, we've heard from Mayor Matatal about the Farley Mowat, the now infamous Farley Mowat, and unfortunately so, given the namesake of the vessel being, this great Canadian environmentalist, and we've received 4 claims in relation to the Farley Mowat, 1 from the town of Shelburne and 3 from the Canadian Coast Guard. We've paid out 3, we've sued for 2, we have judgment for $800,000 in the decision we'll discuss in a second, with another $900,000 just paid out. That, what's the point? What are we doing here, as a whole bunch of legal spend to ultimately be able to recover nothing. This is part of the problem, and part of the offering that the administrator gives as not only a tribunal, but as a subrogated plaintiff upholding polluter pay is, we take that hit. That's what the statute's for. Nobody's going to recover any money from this guy. So what's the point? And I know everybody's here for their, 5 minutes of CPD, so we're just gonna deal with that really quickly. When you're dealing with lay litigants, it's important, like our friend in the Farley Mowat, but why is it that most ship owners are lay litigants, but also kind of border on vexatious? I think the first thing to presume when you're dealing with a lay litigant who is a ship owner is don't presume they're vexatious. I think that's the first tip I would give. As counsel, you always want to be careful not to seem to be on their side or to give them advice or to make them feel like they're otherwise being represented by you, even though you're definitely not representing them. There are things that we see with lay litigants that border on vexatious, which are called organized pseudo-legal commercial arguments, which is like this freeman of the land thing that's coming up from, now and again in the federal courts. Oh, you have no jurisdiction here because, I'm a sovereign citizen, etc. So that happens too. As counsel, you should be amenable and agreeing to, reasonable extensions, reasonable delays, kind of walking them through the process. And this is just the practice. It's definitely the practice in the federal court, where the court is very accommodating, but it's the practice in the bar, to be accommodating with lay litigants and agree to these kinds of things. The bit that not everybody may know about is most recently there's a decision of the Supreme Court of Canada, decision of Pintea and Johns, 2017 SCC 23. We can deal with the reference later if anybody wants to look at it, which adopted these kind of statements of principles for not only counsel but for the courts to deal with self-represented litigants. And I just kind of want to get into a few of those before we move on with polluter pay itself and the decisions. The Supreme Court says by adopting these principles and confirming the decision of the lower court that it was, the court itself, so the judges, the prothonotary, the other registrars and officers of the court and counsel as officers of the court have a responsibility to promote, how do they put it, opportunities for the self-represented litigant to understand and meaningfully present the case regardless of representation. Now, I take that to mean whether they have not whether they have representation or not, but the style in which they are representing themselves. All caps and, flamboyant arguments and etc. And as is the case with our friend in the Farley Mowat, phoning you up to tell you, I know about the plot and it goes straight to the minister. And so, when you see the minister later, you can ask him about the plot. Just touching briefly on these statements of the statement of principles that the Supreme Court is talking about, it's along 3 axes. The court itself and its officers have an obligation to promote rights of access, as it's put. So, you know, kind of explaining to a person, oh, well, you have an option to do this, you have an option to do that, and, you know, Axis B goes more to equality. You know, you have to promote an equal right to the judicial process. It also goes on to say that equal does not necessarily work for everybody in every case. So I think what they mean is equity. You know, that the process has to be fair and understood to be fair by the self-represented litigant. And then the third axis is a positive obligation not only on the court, but everybody who participates in the process to make sure that the self-represented litigant understands that process. And that'll become important in about a second when we deal with, you know, the case of the Farley Mowat, which I've subtitled difficult, you know, irresponsible ship owners, difficult litigants, and bad payers. Now, everybody's seen the ship, Farley Mowat, ooh, it comes in, you know, or when operational, it looked really nice. And now we're dealing with this, which is, you know, credit to CBC, basically a floating dumpster, and it had been for quite a while, you know, and generated the claims that it did. So the administrator brings an action against the ship owner for $800 and something thousand. And there's two reasons this decision is interesting from the polluter pays perspective, and one of which has to do with this self-represented litigant thing that I'm talking about, which is that in that case, the self-rep, the ship owner, didn't really present any evidence. He defended himself, and he showed up on the day of, swinging papers around and made oral arguments that day, but never ended up presenting any evidence in the way of an affidavit or, you know, any real engagement with the court process whatsoever. And one of two things could have happened. One would be to admit the evidence and then throw it out. The other thing that could have happened is none of the evidence was admitted, and that's exactly what happened in that case. Is not, you know, he shows up. The court says basically, you know, you've not proven anything because you haven't put forward any evidence, and, you know, and then kind of went on with the trial. And that's one of the ways that the court can deal with someone in a way that, you know, if you took it in a vacuum, you would think, you know, maybe that could have been done differently. But at the end of the day, you know, this is a person who has caused this much damage, who is borders on vexatious, who was found in contempt of court only like days or months before. And so, you know, when you show no respect for the process, so much so that you are in contempt of the court's process, you know, then there's way more of an understanding to, you know, make an example of. And that's one of the things that this, you know, that we kind of get to in this decision is, you know, the fund is not going to recover any of this money. And, you know, partly that was known going in, but partly it's about making sure that these people are held accountable despite the fact that there is no money. And that's not always easy. The case of the Farley Mowat, so we brought a motion for summary judgment, and on the motion for summary judgment, the question is whether there's a genuine issue for a trial. The court ultimately found there was no genuine issue for a trial. The defendant provided no evidence, despite defending himself, you know, with an actual defense, but he did make oral argument. He then argued that he was not in possession of the vessel because the vessel was arrested, and therefore, you know, liability rests with someone else but not him. Per Rule 483 of the federal court's rules, an arrest does not change possession, and the marshal is not in possession just because he's arrested the vessel. So, as a result, the ship owner, as the last person in possession, remains in possession despite the arrest. So the judge threw that out. And what was really interesting after that is the court says, you know, on this motion for summary judgment, I have to assess the reasonableness of the costs that are being claimed by the administrator. And then says, but I'm satisfied on the basis of the affidavit that a reasonable assessment was performed, and the administrator found that to be reasonable, and therefore this is a reasonable, you know, amount to grant. So that's really encouraging for polluter pay, and the recognition that the administrator's opinion as an expert decision maker is worth something. And it's, you know, understanding that there's no contrary evidence being pleaded necessarily, and in a situation where there was, maybe we'd have to go a different way on this. But it was a nice moment of the recognition of the work that is being done there. That, you know, on the face of affidavit evidence alone, the reasonableness of all of the things that Coast Guard went in and did, and which we thought was reasonable and we paid, was then validated by the court on summary judgment. So judgment was rendered in favor of the administrator, and like I said, you know, as was the case in the town of Shelburne action against the ship owner, not a penny will be recovered here. So there's there's like not a big P but a small p political question of when is it worth going after people. Some people are, you know, are worthy of that pursuit despite their impecuniosity. The second case I want to talk about really quickly talks about is about vessel registration and the relative value of registration. So on one side we've got registration, ownership, sorry, what's registration got to do with it? They're both in French, I've just noticed. And on the other one, and on the French side, we have, I thought, where's my English? And on the other side, we have Maudit Registre, T'as eu ma peau, which is, for my Quebecers in the room, a Michel Rivard reference, so shout out to that. This is a case, the Crown Forest case is very interesting because, okay, let's start with the facts. The facts are, there's an old lodging company that has a barge. It's going bankrupt. The bankruptcy trustee goes ahead and sells this barge. It's an accommodation barge. It's got a house on it. Not really mobile, but it definitely floats. And so it's purchased by a private medical corporation. So basically a doctor who's incorporated buys this barge, almost indistinguishably with his corporate entity, but the corporate entity then becomes the registered owner of the vessel. So this vessel, at the time of the sale, was already known as the Tilton Hilton. So a known pollution risk by almost everybody in the area. And it was definitely a known pollution risk to the BC Ministry of Environment and the local First Nation. And it was on First Nations property, land. So this medical corporation and its directing mind purchase this barge, and then they think, oh, I'm going to move it. Now, why a medical corporation of one person needs a barge with a cabin on it, I'm not sure. But, you know, everybody has reasons. And wanted to bring that up from where it sat to some other location. And very quickly it became apparent that that was not going to be possible. They were unable to actually tow the barge. There were fears that it would cause an environmental, you know, issue, disaster, and people would have to intervene. So, you know, kind of the province and the First Nation says, maybe you shouldn't move it. So the medical corporation decides, well, I'm going to sell this now. En toute connaissance de cause, you know, I know that this is a liability, and I'm going to sell it to somebody who has no idea it's a liability for $1, and does so, sells the barge. The person, you know, recognizes, oh yeah, I'm the owner of a barge, and what a good deal I've just got for $1. But never goes about changing the registration. So at the time of the incident, which happens 2 years after the actual sale almost, you've got a medical corporation that's still the registered owner of this vessel. Now, if you were thinking about, you know, under international conventions, the registered owner is very clearly a defined owner of a vessel. You know, for tankers, it's the only person who's the liable ship owner. And never would you have with a convention vessel a situation where you'd have active registration and no liability would attach. This is almost unthinkable. And here, this is the Crown Forest. I didn't have a good picture like Farley Mowat, so here you have Her Majesty's Hospital Ship, Crown Forest. Whoops. So yeah, so you end up in a situation where you've got valid registration at the time of an incident, and you think any third party who would look at this would go, this is obviously the first person I would go to, and this is obviously the actual person who's liable. To think otherwise would make no sense. And so we, you know, bring the action against the medical corporation, and its directing mind, because, you know, what's a medical corporation doing with a lodging barge, and is that improper purpose, and etc. Corporate veil arguments. And so we're saying, look, how is this fair, you know? And the private medical corporation turns around and says, okay, well, I'm going to sue the guy I sold it to. That person's actually the owner. Come in here and defend with me. Now, that person happened to be dead afterwards, so, you know, that just happens. It happens more than you think, actually. But these were the submissions we made. We were saying, look, this barge is a pollution risk, a known one. It was sold for $1, knowingly, you know, as a way to get rid of it to someone who isn't an institutional litigant. Despite the sale, you know, there was some evidence that this person kind of held themselves out to be an owner, you know, well, during the response, saying to Coast Guard, well, you know, if you want some help or what's going on, and just staying a little too involved, too cozy for someone who, you know, had apparently washed their hands of it. You know, what about registration? What is that worth? And, you know, this is basically the argument we were making. And we were making the argument that registration alone should carry enough teeth to keep you on in terms of your strict liability as an owner of a vessel. And that despite a despite a transfer of title. And part of the argument was that, you know, the Canada Shipping Act, for example, says if a vessel is registered and it changes hands, you have to register the new title. And in the bill of sale, it says, you know, at the bottom of the bill of sale, if you do not file this, full title does not transfer until such a time as whatever, you know. And the court, this is basically what the court concluded, you know. So the court says, look, I hear all of that, but you have a valid transfer of title, and that's the end of it, and that's despite the registration. And obviously the legislation says, yeah, you should do that. You should transfer the registration. There's a fine if you don't transfer registration. There's a fine if you don't declare all sorts of things. And the court kind of says, well, what's that, you know, what's that worth? Has anybody ever used that? Is there any case law on that? And it's kind of sending a signal to, you know, the regulator, like, hey, look, is this worth something or is this not? And you wouldn't believe how many cases we have where you've got a bill of sale, you know, which is basically loose leaf paper, or the scan of a loose leaf paper from like 6 years ago saying, yeah, I gave this to somebody, no signature, no dollar amount, no invoice, you know, like just no evidence of any of that. And it's a bigger problem in BC than anywhere else, but it happens. And so now we've kind of come to this place where there's seemingly a gap, you know, that the definition of owner is being interpreted a little too restrictively because, you know, the court said, look, this person wasn't the owner at the time of the owner. But there can be many owners at any one time. There can be many registered owners. There can be many shareholders. There can be, you know, under convention law, you can have a whole bunch of different people strictly liable at the same time. So, you know, is this definition being interpreted too restrictively such that it will require amendment? It's a valid question. And a case that considered that and that was favorable to the administrator, but ultimately now is turning out to, you know, inform decisions that are saying the owner, is the decision of the Chilcotin Princess. In that decision, the administrator filed an action against the province of British Columbia. That action was stayed pending these proceedings. And the reason we filed an action against the province of British Columbia is that at the time, before the incident happened, before the pollution incident, the ship, Chilcotin Princess, was owned by a provincially incorporated corporation, you know, just whatever, BC Inc. And prior to the incident, that corporation became dissolved, such that BC corporate law provides that the title to that vessel escheats to the Crown. And the Crown knew about that, and knew about the pollution incident, knew that everything was going on, and knew or should have known that they would have become the owner at the time. And so we end up in a situation where then we turn around and we say, well, look, you knew, the registration, you know, the company died, you became the owner, this is now your problem. And if this holds up, you know, on appeal and then we go to federal court, then other provinces should be worried, including Nova Scotia. But, you know, in that decision, the BC Supreme Court here, okay, no, let me back up. So the province, being sued, decided, okay, well, I don't really want to be sued. What am I going to do? I'm going to try to reinstate the corporation, and I'm going to, which is fine, you can do that, but I'm going to try to reinstate it with prejudice to the administrator's claim. So try to reinstate it as if it had never dissolved, but also try to kill off the administrator's claim. And the court, the Supreme Court said, well, okay, the default position is, that's fine that it can be reinstated, but it can't be done so in such a way that it would defeat legitimate claims. And the province, you know, the province argued pretty hard, and we ended up winning that decision. And interpreting the Marine Liability Act, the court said, no, look, you were the owner at the time of the incident itself. You knew or should have known or should have done something, and therefore, you know, likely you'll be found liable. Now, the liability part has no bearing on the federal court action where liability will be decided, but the issue of the owner at the time was then used by the court in the decision of the Crown Forest that we just discussed. And that was part of the reasoning to say, hey, look, you know, I'm not necessarily sure about this registration thing and what the residual value is, but I'm definitely satisfied that at the time this was the one single owner. And so that, I think, is interesting. Taking a decision that, you know, though really favorable, ended up having, you know, or being part of something that had an unfavorable consequence on the administrator's claim. Given time, I'm not going to talk about the Clipper, and I just want to wrap it up. And I want to say, you know, you've heard here today a lot of the good things that the fund has done in the last 30 years, and that definitely includes trying to uphold polluter pay, even though it's difficult. And some of the things that we have to think about moving forward for the next 30 years are, you know, it's not an easy principle to uphold, and it can be for many reasons. They can be evidentiary. You know, what evidence is offered to us on assessment of the claim, what evidence exists 5 years after we've done that, you know, what if there was sabotage, what if there was this. The recovery rate is really, really variable or mixed, and by that I mean, you know, depending on the metrics you use, a lot of times there's no money at the end of the day. And if there's no money, then can you really say, even if you have a judgment on liability, if you can't get paid, what's it all about? You know, and that's fine for the administrator not to be paid. That's part of the statute. But for a local community, let's say you miss a time bar, let's say, you know, something happens and you have to be the one to sue or bring those actions. What do you do? And what hope, if any, do you have of actually recovering anything? And I think the question is legitimate, you know. How do we make sure that people who own vessels have either the financial capability or the insurance to be able to pay for third-party claims? That's definitely a big impediment to polluter pay. Regulation of certain types of craft. You know, we've heard, you know, tankers are the big thing everybody's thinking about, but tankers are the most safe segment that we have in our portfolio, as are international vessels. You know, it's not club vessels that cause the majority of incidents. What do you do about that? What do you do about regulation of small vessels, pleasure crafts, and the things that ultimately become derelict and abandoned? What do we do with that? What about the prohibitive cost of access to justice? You know, if somebody wants to do this themselves, they're out how many, $50,000, $100,000, $150,000 worth of, you know, of time and spend and etc. running after somebody who has no money at the end of the day. That's not, you know, that's not in the polluter pay spirit, you know, which is kind of why the fund is here. And another thing is we don't have a lot of case law. A lot of people ask me, you know, David, do you have, you know, some guidance on this or that or whatever? And at the end of the day, the commercial stuff settles and the insurance people are, you know, are reasonable and settle, and the big crusty, interesting questions don't necessarily get litigated, and what you end up with is decisions like, you know, on summary judgment or on default or on issues that are kind of borderline, and you have to take a stance on in principle because otherwise you're not going to get anything to move that case law. So these are some of the things to think about in the, you know, in the interpretation and application of the polluter pay principle. And though not, you know, the deepest of legal dives, just because of time, you know, I'm happy to take any questions now. I'm happy to chat about it later. But yeah, thank you for listening.
you.